Good morning. This is call number 2012-884 in the interest of Carmen and Eleanor Alvarez. Please raise your right hands to be sworn. Parties, you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Ma'am, please state your name and your relationship to the children.
My name is Penny Longoria, and I'm their mother.
All right, sir, your name and your relationship to the children.
Jacob Alvarez, and I'm their father.
All right, Mr. Alvarez, please state your name and who you represent.
Stacy Valdez for the non-movement Penny Longoria.
All right, and counsel, your name and who you represent.
Joanne Wogu for the father, Jacob Alvarez.
All right, for the state.
Jacqueline Adiemi.
All right, we've got a agreed child support review order. Is that correct?
No, Your Honor, we're here on a motion for new trial.
All right. Who presented that?
The Office of the Attorney General.
All right, let's move forward.
Okay, Your Honor, we're here because we filed a motion for new trial because we saw the incorrect order according to the code. We're asking that the court grant us this new trial. We're not asking to change the order, and we're not asking to change the order, and we're just trying to go in. We're just trying to move with the interest of justice due to the Supreme Court extending the timeline due to the pandemic.
All right, is this agreed by all parties?
No,
It
sir.
was agreed. Previously, it was agreed, Your Honor, my client and I have signed the order because it doesn't change a material fact or anything within the order. It's still the exact same language from the previous order. So my client and I have signed the order.
Your Honor, may I respond?
Yes, ma'am.
So this order, the original order, the erroneous one, was signed February 5th, 2020. The government files a motion for new trial on March the 4th, 2020, and presents another order to the court called an agreed support order. And that was signed by the court, Your Honor, on March the 5th, 2020. So the operative date is March the 4th, 2020, was when they filed the motion for new trial. And the February 5th, 2020 order, if we had, basically, Judge, the time is told for the court because 75 days after the order was signed on March the 5th, 2020 was May 18th. So that means the motion for new trial was overruled by operation of law. And then the additional 30 days puts us to June 17th, 2020. No notice of appeal was filed. So the plenary power of the court to set aside either of these orders has expired. With regard to the extension by the Supreme Court for the COVID, the Supreme Court in its emergencies orders in the most recent one reiterated the same timeline that was out in the very first one in March. And what it said was it's going to toll deadlines in civil cases from any deadline that was to hit between March 14th, 2020 to June 1st, 2020 was tolled until July 15th, 2020. Now, it specifically exempted or accepted appellate deadlines. Appellate deadlines were not extended during this COVID emergency order. But even if the court were to think that the motion for new trial deadline does not fall under the appellate deadline category, the Supreme Court order extending the deadline timelines, it expired July 15th, 2020. So there's just no road that ends in the court having plenary power to set aside this order. And the order that they're trying to enter, as Miss, I'm going to butcher your name and my apologies, Nwagu said, is in substance identical to the March 5th, 2020 order that this court signed. So I don't understand why we need the motion for new trial. But even if the Attorney General thinks we do, the deadline's gone. The original one expired on June 17th, and the Supreme Court order, even if it did apply, which it does not, because this is an appellate deadline, but even if it did, the Supreme Court emergency order expired on July 15th, 2020. This court just doesn't have the plenary power to grant the new trial.
Ms. Adeyemi, you're saying the court mistakenly signed the wrong order, meaning you submitted the incorrect order?
Yes, Your Honor, the incorrect order was, yes, Your Honor, the incorrect order was submitted. It was a non-judicial order that was submitted to the court.
What is the difference between, and what are you trying to do now? What is the new order?
The new order is the same thing. It's a modification, just a judicial order it's just in accordance with the code. The order that we submitted was not in accordance with the code.
Why? Why is it not in accordance with the code?
Because it was a CSRP, Your Honor, and we were in the court, and it won't allow the parties to come back, and it won't be, what I was told by my managing attorney is that it won't be able to, we won't be able to enforce it against the parties.
Why?
Because it's a CSRP, and they weren't in a CSRP setting. They were actually in the court. It should have been filed as a judicial order.
Your Honor, I think that's a distinction without merit. And even if it were with merit, the plenary power expired on July 15th, 2020, in the most generous reading of the rule of the Supreme Court order. But the Supreme Court emergency order specifically exempted appellate deadlines. And the district court did not extend any of the deadlines. And so I think it's a distinction without merit. I don't think me nor my opposing counsel would argue that that order is not enforceable. And thirdly, we're in a mod now anyway.
Yes, Your Honor.
Just to add, we are scheduled, right? We are scheduled this morning also for mediation right now at the same time for 9 o'clock. For the petition to modify that was filed.
There is a motion to modify on file?
Yes, Your Honor. There was a lot of confusion regarding this. Our case got disposed of previously in March when we signed the order. We had to refile our petition to modify afterwards. We actually got set coincidentally today for this motion for new trial, but we're scheduled for mediation for 9 today right now as well.
Yes, Your Honor. We want to modify the order that is in place now. Yes, Your Honor.
All right. The AG's motion for new trial denied.
Thank you, Your Honor. May we be excused?
Yes.
Joanne, you don't want to argue your transfer?
Oh, I'm so sorry, Your Honor. I did also file a motion to transfer because custody is an issue here. Conservatorship is an issue here. And so we're going to be dealing with a lot, and I'm asking, and we're set for mediation. So I would like to be transferred over to the district court.
So, Your Honor, I don't have an objection to be referred back to the district court. I think a motion to transfer is probably.
And I also filed a motion to confer with the child, Your Honor.
But because we're not transferring out of the county, but that wasn't set today. I did get it yesterday. I don't have any objection to being referred back to the district court.
What court are we in?
246.
Graves.
246,
Your Honor.
and the motion to modify is on file already, right?
That's
Yes,
correct, Your Honor.
Yes, June 12th.
All right, this matter is transferred to the 246 District Court.
Thank you, Your
Thank
Honor.
you.
Thank you, Jackie.
Excused.
Thank you.
Thank you, Judge.
Morning, Koya.
Good morning.
Is it just one party?
No, so the custodial appearance on, the non-custodial appearance not here, but his attorney, Ms. Wilder, should be logging in to this one.
What's the case number?
It is, sorry, 1 second. This is case number 9, so it's 2